I would like to introduce lawyer Akaho. So lawyer Akaho is one of our speakers this evening. He is the founder of Wise Heart Solicitors, which is based here in the UK. His practice specializes in immigration, family law, Ghanaian customary law, and practices civil litigation. He is a prominent feature at many local events on TV, radio, and social media platforms, where he offers advice on topical issues. He also provides counsel to Ghanaians in Arab countries who wish to travel to Europe and the UK and the US on how to apply for visas in that country without returning to Ghana. Mr. Akaho is married to his sweetheart, Matilda Akaho, and they have two beautiful children, Adelia and Sam. So over to you, lawyer Akaho.
Thank you. Thank you very much for that concise introduction. I'm very grateful, and thank you all for being on the platform. I thank God for giving us the gift of life, that we are in the midst of the living today is just by his grace and mercies, not because we deserve it, but just because he has gifted it to us. Thank you all. Right, I have 20 minutes to speak. It's now 3:08, so by 3:28, I should be done. I'll try as much as I can. It's a lot to say, but I'll try to compress it as much as I can. And mostly what I'm going to say, well, everything I'm going to say is about the United Kingdom, UK. So, first of all, United Kingdom operates, well, when we say the United Kingdom, I believe we all know it's made up of 5 countries, or maybe it's 4 countries. We have News, N-E-W-S. That is what makes the United Kingdom. Northern Ireland for the N, England for the E, W for Wales, and S for Scotland. These are the 4 countries that make up the United Kingdom. So just remember News, and then you know it's the United Kingdom. We operate 2 types of laws. It's a combination of rules. We have the immigration rules, and then we have the EU laws. The UK was in the EU, and as a result, whatever the European Union decided, was enforced on the UK. So UK had been operating 2 rules, UK laws and the EU laws, until recently when the UK left the EU. That was Brexit. I believe most of you heard of Brexit. That was on the 31st of December 2020. So, and even now, we have the EU laws, which have now been codified into Appendix EU. It means the UK is still operating the immigration rules and the EU laws, but in a very, very defined way as it is now, particularly with reference to the EU laws. So let me look mostly at the UK laws. On the 9th of July 2012, there was a massive change in the laws of the United Kingdom, and in this case, the immigration rules. Before the 9th of July 2012, anybody who was in the UK for 14 years, legally or illegally, could, or legally and illegally combined for 14 years, could go for indefinite leave to remain or permanent right of residence in the United Kingdom. On the 9th of July 2012, that changed. Our Prime Minister, Theresa May, at the time was the Home Secretary, she changed the rules. And she said 14 years was too short, and therefore they took it to 20 years. So you had to be in the UK for 20 years before you can get your leave to remain if you are in the UK unlawfully or without documentations. It changed from 14 years to 20 years. Other changes that came into effect on the 9th of July 2012 were that if you are in the UK, you are a British citizen, or you had indefinite leave to remain, and you want to go and bring your spouse, you had to meet some financial requirements. It was previously maintenance, but from the 9th of July 2012, it changed to financial. So we had maintenance and it was changed to financial. Financial means you had to be working and be earning £18,600 before tax a year before you can bring your partner, either your husband or your wife. 18,600. And if you have a child, the first child will be £3,800 on top of the 18,600, and the second child will be 2,400 on top of the 18,600 plus 3,800 plus 2,400. And every additional child is £2,400. So if you do the maths, if you are not earning that much, you cannot bring your spouse and your children to the UK. So strategically, some people will bring their spouse first. Now, when she is working and he is working, they both combine their income and that raises it before they can bring their children to join them in the UK. Before the 9th of July 2012, there was no requirement for English language test. From the 9th of July 2012, you have to pass, or your spouse will have to pass the English language test at level A1, speaking and listening, before they can come and join you in the UK. Unless they have a first degree. And with the first degree, then they don't have to write the English language test, but they would have to send the degree certificate, the transcript, and the letter of proficiency in English to an organization called ECTIS. It used to be NARIC. It's now ECTIS, ECCTIS, for them to confirm if the degree you have or you had in Ghana is equivalent to a degree in the United Kingdom before you would not be required to write the English language test. So now it's a requirement. If you're married and your wife or your husband cannot speak or understand English, they are not coming to the United Kingdom. They can. They will just not come. Unless you take them to school, you let them at least understand the communication. They can communicate, they can understand, and they can also communicate before they can come. They would have to pass that test before they can come to the UK. So those are some major changes. The English language requirement, the financial requirement, which is 18,600 for your spouse alone. If there's a child involved, 3,800, another child, 2,400, and all additional children, 2,400 before your families can come to the UK. So that is one part of the rules. And also the same 9th of July 2012, there were other changes as well. And this is what was introduced called Appendix FM. Appendix FM, the FM only means family, stands for family root. FM, family root. Now, what that means is that there are certain sections of the rules. We have the suitability requirement, and then we have the eligibility requirement. Suitability means you are suitable. You have no criminal records. You do not owe the NHS. You haven't been to the hospital and they gave you a bill over £500 and you refuse to pay. There is no deportation order on you. You do not have immigration debt. You went to court, you lost the case, and you were asked to pay a fee and you refused to pay. And some other requirements. If you do not have any of this on you, or your partner doesn't have any of this on them, then clearly they meet the suitability requirement. Then we come to the eligibility requirement. We have RIFE. R stands for relationship, I stands for immigration, F stands for financial, E stands for English language, and the A stands for accommodation. RIFEA. 5 requirements: relationship, immigration, financial, accommodation, and English language, RIFIA or RIFIA, whatever you call it. So these are the requirements before you can apply to stay in the UK. Now, if you are in the UK, you have overstayed your visa, and you want to regularize your stay, there are requirements, and that comes under Appendix FM, Section LTRPT. And the LTRPT means leave to remain as a partner or as a parent. If you want to apply based on your child, then it is Appendix FM, Section LTRPT 1.1, with reference to EX1, which is exception 1 of the rules. It is an exception because once you overstay, you are required to go back to your country before you come back after 1 year. When you were coming to the UK, you said you were going to go back. When you went to the interview, they asked you, will you go back? You said, you made a sign of the cross. Yes, I'll go back to my country.
Yeah, right.
You came and you did not go back. So punishment is go back to your country, stay in your country for 1 year before you can come back to the UK. But because there is a child involved, because of the child's welfare, well-being, and upbringing, that is an exception. You don't have to go out to come back in. They don't want to separate you from your child because of the bond you've created with the child. They don't want to split you. So that is EX1, exception 1. So if you enter the UK and you don't want to go back, then look for a woman and quickly start doing what you have to do. That is if you're a man. And if you're a woman and you don't want to go, then I would say start fishing for a man who has a child, or you have a baby. And once you have a baby, the child is a British citizen, you are not going anywhere. You will get your stay in the United Kingdom. So the EX1 is a child, and then we have EX2, exception 2. That is medical reason. If there is a medical reason why you cannot go back home, or your spouse has a medical reason, if you left them, they cannot go for their medication, they cannot manage, they cannot do their cooking, their washing, their cleaning, and you do everything for them, that is exception 2. Because of the EX2, you will be required to stay in the UK with your partner, or even if you have no partner, based on your own medical conditions, you can be allowed to stay in the UK. The UK operates different rules. I have mentioned the EU law, the immigration rules, the immigration acts, and other ones. I will respond to that later. So, Appendix FM, Section LTRPT, that is for parent. Appendix FM, Section LTRP is for partner. If you overstay, you cannot go onto the parent route, the partner route, unless your partner has a child. Even if the child is not your own child, the child becomes your stepchild. You will stay because of your stepchild. We make the application. We have to show that you are involved in the child's life. You take the child to school, you collect the child from school, the child is going to hospital, you are involved. With this, we are able to get a letter from the GP or from the hospital. We would apply and you will get your stay in the UK. I'll quickly go to another one, another appendix that was provided from the 9th of July 2012. That is Appendix PL. PL stands for private life. Now, assuming you have no wife, you have no husband, you have no child, what do you do to stay in the UK? No wife or husband or child or medical problems. How do you stay in the UK? The law says under Appendix PL, P stands for private and the L stands for life, private life. It means if you are between 0 to 18 years, if the child or the person is between 0 to 18 years old, they have to be in the UK for 7 years of their life. So assuming you came to the UK with your child who was 2 years old and the child is now 9 years old, it means the child has lived in the UK for 7 years. You can apply under Appendix PL for the child, and the parent will then apply under Appendix FM, Section LTRPT. The child is PL, and the parent is the family life based on the child. You will both get your stay in the UK. So 0 to 18 years is 7 years in the UK. 18 years to 25 years, you have to be in the UK for half of your age. If you are 18, it means you have to be in the UK for 9 years. If you are 20, half of that is 10 years. If you are 22, half of that is 11 years. So between 18 to 25 years, half of your life in the UK, then you can also apply and you'll be granted your leave to remain. If you are under 20 years, then you have to prove, okay, let me look at the 21. If you're 25 years and above, so I said 0 to 18 is 7 years in the UK, 18 to 25 is half of your life, 25 years and above, you have to be in the UK for 20 years before you can apply to stay. And you have to prove that you've actually been in the UK for the 20 years. Your medical reports, your bank statements, if you've been working legally or illegally, we still use it because there are case laws. The case of Mahmoud says that they know that you will by all means survive, you will by all means leave. So even if you work illegally, that should not be used against you. So even if you work, we use your pay slips, we use your bank statements, we use your P60s, your employment history. We put all of those together for 20 years. We apply for you, you still get your leave to be in the UK. So if there is anybody in the UK who has been less than 20 years, but they can prove that they are not able to go back and integrate into their country because they've been tortured or they've had some political affiliations which exposes their life to danger if they should go back, then that can also be used. It means you have not been in the UK for 20 years, 25 years, but you haven't been in the UK for 20 years, you don't have any medical, you can also apply, but that is normally 50-50. It's not guaranteed if you are under 20 years. Once you hit the 20 years, I can almost certainly guarantee you will get your stay in the UK if you have the evidence to prove. So that is Appendix PL. Then we can also go on to adult dependent relatives. Maybe you want your mother to come and join you. You want your brother to come and join you. You want your sister to come and join you from Ghana. There are also provisions, albeit quite difficult, because they have to prove something we call, I call it AIDS, AIDS. Age, A stands for age, I stands for illness, D stands for disability, and S stands for support. If you want your adult sister, brother, uncle, nephew, niece to come and join you, your mother, your father, you have to prove that they meet AIDS, AIDS, age, illness, disability, support. They meet this requirement before they can come to the UK. Then we quickly go to the BNA, British Nationality Act of 1981. Now, if a child is born in the UK and the father has indefinite leave or the mother has indefinite leave, automatically that child is a British citizen. So once they are out, you can almost immediately apply for their British passport for them. They will get it without any questions at all. That is under Section 1.1 of the British Nationality Act of 1981. Now, if you go to Section 1.2, if the father or the mother is in the military, they also, the children, once they are born, are also British citizens automatically. So once you join the army, the Air Force, or any of the forces in the UK, even if you have 2.5 years limited leave to remain and you give birth to a child, automatically that child becomes a citizen of the country. So that is also another rule that we use. Now we go to Section 1.3 of the British Nationality Act 1981. Again, if any of the parents at the time the child was born is not settled, the father doesn't have indefinite, the mother has nothing, but later the father or the mother becomes settled, you then have to register the child as a British citizen. This is the difference. Section 1.1, the child is automatically is automatically a British citizen because the parent was settled before the child was born. Section 1.3, the parents had nothing before the child was born, but later they got their settlement. Then you have to register the child as a British citizen. And that will cost you about £1,250 before the child gets their British citizenship. And then we get to Section 1.4 of the British Nationality Act of 1981. That says if the father has nothing, the mother has nothing, the child was born in the UK, the child has lived in the UK for the first 10 years of their life, that child will be registered as a British citizen under Section 1.4, Section 1, subsection 4 of the British Nationality Act 1981. Once that child becomes British, all the parents, both parents, father and mother, can base their application on the child in the UK, and they can also get their leave to be in the UK. They do not have to go out of the UK to apply to come back. They will both apply to stay in the UK because their child is a British citizen. The other provision is if the child is 7 years old, you can apply to get your 2.5 years limited leave to remain. You can renew 4 times. But once the child hits 10 years, they move from the 2.5 to British citizenship application, and they would all stay in the UK as well. So this is just a summary. It is exactly 3:28, and I have exhausted my 20 minutes. So I would rather ask that if there are any questions, I will take it and then we progress from there. Thank you very much.
Wow, that was absolutely amazing. Thank you so much. I learned so much. So we have a first question here. The question is, can undocumented people living in the UK get free medical care?
Yes, undocumented people can live in the UK and access medical care, but mostly it must be A and E. You have to attend the A and E. Now, several years ago, people were able to register with their GPs without any problems. So those who are already in the system, once you've been with your GP, your general practitioner for the years, they don't ask you for your documentations at all because they've known you, they've attended to you, they've seen you for the years. But anybody who is now new in the system, you may be asked for your leave to prove that you are documented. If not, if you're unwell, you would have to go to the A&E. They will treat you without any charges. They will not say you don't have papers and therefore will leave you to go sick or to die. They will certainly treat you. I've seen that there are some GPs or GP practices that register people online, and they still attend to them regardless as to whether or not they have their documentations or not. So some GPs are quite humane and others are very strict. So I would rather advise that if you happen to be in such a category, you explore and go to the area where they don't ask for too much details, and you can register, you can have your medical treatment at any time.
Okay, thank you. So we have a question from Hetty Abraham Quartin. She's got a question on behalf of her brother who is divorced from his wife. They have a child together.
Yes.
And she wants to know if there is a program that can allow him to migrate to the UK so that he can be in the child's life.
Right. Where is he? Is he in the US or outside the US?
In Ghana.
He's in Ghana, yes. Yes, there is this provision, appendix, family life as a parent of a child, of a British citizen child in the UK. Appendix, family life as a parent of a child, of a British citizen child in the UK. Yes, the law is there. It is possible to apply, but the requirements are quite high. One, you have to show that there is a court order that gives you access to the child when you come to the UK, or there is an agreement between you and the child's mom that you would have access to the child when you come to the UK. That is one. Number two, you have to prove that you have accommodation where you will live without recourse to public funds or asking the government to give you accommodation. 3, you have to pass the English language test at level A1 to show that you can communicate when you come to the UK. The next one is you have to show that you have employment that you will get into immediately you come to the UK, so you don't need the support of the country to look after you and your child. So these requirements are there. It's sometimes difficult to meet the employment one and the accommodation. Accommodation is not too much of a problem because a family member can say, yes, I can accommodate you here and there, but the employment is sometimes the issue. If this can be satisfied, yes, then they can apply to come and join their child who is a British citizen and be part of the child's upbringing. Appendix FM EC as entry clearance as a parent of a child, of a British citizen child in the UK. That is the rules. If you go on the immigration rules, it's all there and it can be read.
Right, okay, thank you. I have a question. My partner has got leave to remain in the UK, but uses a Ghanaian passport. So if we want to travel to Europe, how do they apply for a Schengen visa?
Great. If your partner has leave to remain and not a British citizen, then they have to apply, like you rightly said, for a Schengen visa. It could be to any of these countries, Germany, Portugal, Spain, France. The normal application process is become very difficult because of Brexit. I think all the countries now hate the United States deciding to leave the EU. So it's become quite difficult to get the Schengen visa, but you still have to apply. Once you pass through everything, they get a visa, they can travel with their partner in and out. Even the partner who has the limited leave will still need the visa to travel. The only person who would not need a visa is one who holds a British passport. They can travel in and out, but everybody else will need a Schengen visa to go to any of the European countries.
I have a question.
Yes.
Hi, I have dual citizenship. I have British and American citizenship. I just went to renew my British passport.
Yes.
And they requested a copy of my American passport, which I sent to them. The two passports have a slightly different name.
That's correct. I know exactly where you're going.
And they turned me down, asking me to change the name on my American passport to match the British one, or vice versa. What do I do?
What do you do is to do what they have asked you to do.
Okay, so the difference is my name is hyphenated.
Yes.
My last name is hyphenated. My American passport has my last name, exact same name, but they've used the first last name as my middle name.
Yes. I understand you. Now, recently, the UK, they were introducing some rules that could enable the Secretary of State to take your British citizenship away from you without even knowing. It's because of these people who got involved in these terrorist activities, these girls who went to Afghanistan to fight and all that stuff. They were British citizens, and afterwards they were fighting to come back to the UK, and the UK said, no, you can't go and fight and then come back of the source. So they were trying to take away the rights without even you knowing. It's been contested and they've lost anyway. So what it is the UK is trying to ensure that every person carries one name, or whatever name you have in one passport must match all the passports you have. The names will have to be the same. It happened to me. It happened to my friends. It happened to my pastors, my clients. If you have a slightly different name in another passport, they would ask you to bring both passports. And if it is not the same, you have to do a deed poll or change of name deed or swear an affidavit to make sure the names are the same before they will issue you your UK passport. They do not want the same person to have two different names in two different passports. The names can be the same, But even if the position changes, maybe Ellen Ajua Amponsa in one passport. In the other passport, it is Ellen Amponsa Ajua. Is the same person, but realize that the positions of the names have changed. To them, you are not the same person. So both names will have to be exactly.
Mine is just hyphenated in one and not hyphenated in the other. Is the
Yes.
hyphen?
So you have to make sure the other one is hyphenated as well to be exactly what it is in the UK passport. Otherwise,
well, I've paid £139 or whatever it is to renew it. Do I get that back, or do I have time to change it? Because I'm getting ready to go to Ghana, and I cannot get my American passport until I return from Ghana.
Usually they will give you time to, I mean, those that I have dealt with, they give them, I think, 21 days or so, or 14 working days to make the change and bring it back to them. They don't just refuse it straight away. They give you time to correct it. And
14 days is too short for me to do anything before I leave for Ghana, though.
Well, in that case, you can withdraw the application, go to Ghana and come back and resubmit the application after you've made the changes so that you.
So I can write to them to withdraw the application.
For now, yes, you can.
Okay, I'll do that.
Yeah.
Thank you.
You're welcome.
Okay, thank you. We have another question from
Sure.
John. So he wants to know what can be done if somebody has got a work permit, but the agency hasn't gotten you a job since you came to the country. So what should that person do?
It's a huge problem in the UK now. Now, a few months ago, from sometime last year, the government introduced this health and care worker visa. Because of COVID-19 and Brexit, there was a lot of vacancy in the health sector. So the government categorized healthcare workers as shortage occupation industry. So a lot of people, nurses, doctors, care workers from all over the world were allowed to come to the UK. As I speak, that chance is still there. And then later, they give teachers, science teachers and English language teachers the chance. And again, they've given construction workers the right to come to employ people from outside. And now they're giving the chance to prison workers, in other words, prison officers, to come to the UK. Now, the problem we are having is this. You need a sponsor. The sponsor must have a sponsorship license from the Home Office. And then they would issue the employee something we call COS, Certificate of Sponsorship. Unfortunately, it's looking as though people are profiting from it. They're bringing people to the UK where they don't have work for them to do. So a lot of people have come as health workers, 8 months, a year, there is absolutely no work for them to do. What should you do? If you can get another employer in the same sector, if you are in the health sector and you can get another employer in the same health sector who has job or who has vacancies, then you can apply to them. Then they will give you the COS, another certificate of sponsor. Then you switch from them to the new employer to carry on working. Or if you can get at least 20 hours in the same health work sector, it shouldn't be in a different sector, in the same sector as you've been given your visa, then you can at least do 20 hours with them before you look for another option. Nothing stops you from switching to a parent route or to a partner route. You can switch if your circumstances do change. Rather than waiting for 2 years, 3 years, 5 years, and then you have nothing to prove that you've lived and worked in the UK, then you cannot be able to extend your visa after that period of time. So I would tell people, go to the NHS website, apply for jobs. As for the NHS, the National Health Services, they cannot say there is no work for you. If they have the sponsorship certificate, they issue it to you, they take you on, then you can work with them. Don't sit down until the 2 years is up, 3 years is up, 5 years is up. Look for some options and then you can switch.
Okay, thank you. Does anybody else have anything that they would like to ask?
Yes, I have some questions, some post presentation questions. Do you have those too?
Yeah, I do. Okay. So the next question is there a place for people to learn where they can actually learn more about the UK immigration rules?
Yes, lots of places. In fact, too many places. Now, the UK does not operate a written constitution, so all their laws are all in the air and everywhere and everywhere. So the first point of call is the Immigration Act 1971. Immigration Act of 1971. That is where you can get all the rules from, the Immigration Act of 1971. From there, you can then go to the immigration rules. Just go online, go to Google and enter immigration rules. If you give it everything, it can be very confusing, but it's there. So we have the Immigration Act, we have the immigration rules, then we have the appendixes. That is the changes that have been made to add up to the immigration rules. Then we have the policy guidance. The policy guidance, those are written in simple English for anybody to read. You don't have to be an attorney, you don't have to be a lawyer to read those. Those ones have been written in plain English for anybody to understand. That is the policy guidance. And of course, the Home Office website, you can go there, just enter news and updates. All the rules and all the changes are there for you to read. Interestingly, there are other private sectors or private sites where you can also read. There's a place called Free Movement. Free Movement is a site that publishes all the changes in the UK laws. So if there is something today, if something changes today, you get it at Free Movement. It updates automatically. It's updated every now and then. And of course, all the rules, all the changes, all the HCs, the House of Commons changes, updates, and everything, you can get it so from there. So we have Immigration Act, immigration rules, the policy guidance, the case worker guidance, the Home Office website, the immigration news and updates, the gov.uk sites. You can also go there. You can also go to Free Movement, and also you can go to the Citizens Advice Bureau websites. You have all the changes there. But I always say, reading the law is one thing, interpreting it is another thing, applying it to the fact is a different thing. You can read the English, but the interpretation can be different, the application will be different. So it's still good to read, to know, and update yourself, but it's always better to speak to a legal person if one wants to proceed with any sort of application. Thank you.
Okay, that's fantastic. Thank you so much. So we have the final question for you this evening, Lawyer Akaho. And the question is, what are my rights as a non-citizen if the police stop me in traffic or come to my home?
Well, if the police stop you in a traffic or come to your home, certainly they will tell you the reason why they are there. They would not just come and bundle you up and wrap you up in Ghana Must Go and take you home. No, it doesn't happen that way. They will have to give you the reason why they are there, and then you have the choice. Of course, you don't have to give them your telephone. People, sometimes, unfortunately, my people are a bit timid. So when they see the police, they begin to shiver, and whatever they ask, they give. You don't have to give them your telephone. You don't have to give them your cell phone, because that is where they scroll through and find all kinds of things. You do not have to give it to them. And also, you do not have to answer questions. You can decide to go quiet and tell them you need a legal representative. If they want to take you to the police station, you can go with them. And certainly, they have to give you a duty solicitor. In other words, a lawyer that is on duty. They always have a lawyer on duty. So you can use them first, and subsequently you can change to another lawyer that you prefer. So if they do come to your home, of course, they must tell you the reason why they are there. You decide to answer questions or not, ask for a legal representative. They have to give you a duty solicitor. If they detain you for any reason at all, you then have to start the bail process. And the bail process can be done through the Chief Immigration Officer's bail, or we go for the court bail. they may give you something we call immigration bail. That is, you should be reporting to the Home Office to show that you are still in the country. Now, if you have a family, you have a child, it's always good to inform them where you decide to speak. It's good to inform them that, yes, I have a child. My child is a British citizen. I have a partner who is a British citizen. Let them know. They will have this on record because that will be the basis on which your application may succeed or fail if you don't tell them from the beginning. So nothing to be worried about. Let them come to the house, confidently speak to them. They are human just as you and I are. The only difference is they are wearing a uniform that gives them authority to come to your home. But even that, they must have the warrant to do so. Nothing to be afraid of. Confidently speak with them. If you decide not to answer, ask for a legal representative and who will run with your case for you until you get settlements in the UK.
Okay, that's absolutely fantastic. Thank you so much, lawyer Akaho.
Sorry, I have a question.
Yes.
So I came in as an IT staff to the UK, and then I've gone for a couple of interviews, and then I passed on the interviews, but they asked for my share code. So once they see my share code, they'll be like, "Oh, I'm sorry, we can't employ you." And then I've gone for over 10 interviews, and then the same story. Everyone turns down the offer. I want to see my share code. And it's becoming a worry to me that, like, because I haven't gotten a job from my agency yet. And I don't know what can be done because they don't want to also give the offer because they'll be like, "Oh, we can't employ you based on the law that says that we can't employ somebody with a COS."
Yes. You came with a COS with a particular employer, right?
Yes, with the same employer, but you can't work elsewhere. And then this employer doesn't have any job for you to do. And then you can't also find a job on your own. So it's been hell.
Okay, I can understand your plight, my brother. The companies you've approached, do they have the COS too? Do they have a license to employ?
I can't tell for that.
Yes.
Yeah, I cannot guarantee.
Go to Register of Licensed Sponsors. Go on Google and enter Register of Licensed Sponsors, UK.
Okay.
Register of Licensed Sponsors. It will give you all the companies that are licensed by the Home Office to employ or who can issue COS. If the companies you're approaching do not have the sponsorship license, they cannot help you. But if they are on that sponsorship license, the list is a long list. Thousands of companies are on that list. Take your time, go through it. If they are on that list, then you can rather apply to them for a COS first. Once it is granted, then they can then employ you. Going straight to them without ensuring they have a COS or license will not help your situation at all.
Okay. Thank you very much.
You're welcome. Register of Licensed Sponsors. Register of Licensed Sponsors, yes?
Okay, so thank you so much. How can people get your contact details, Lawyer Wisdom, if they wish to contact you outside of this this program?
Thank you. We are based in London, Dalston Junction, Hackney, actually, more or less in the city. Those of you who know Dalston Market, I am very close to the Dalston Market, behind the McDonald's. The address is Y-Smart Solicitors, Y-Smart, W-I-S-E-M-A-R-T, Y-Smart Solicitors. I am Wisdom, so wise. And then my wife is Matilda, so it's Smart. So Y-Smart Solicitors. So that is how we came with the name. And it can also mean wise and smart. So whichever way you look at it. So it can be wise and smart or wise and Matilda, whichever way. So solicitors, we are based at Dalston Junction, number 8 to 9, the Print House, 18 to 22, Ashwin Street, Dalston. E8 3DL, Echo 8 3 Delta Lima, E8 3DL. And the telephone number is 0208 0165 384, 0208 0165 384. My mobile number or my cell number is 079 31 411 042. 079 31 411 042. Those are the details. If you call the office number, you would always have, we are 4 solicitors there. Myself, Lawyer Francis, Lawyer Nanamwa, and Lawyer Rosemary. And then we have other staff there who would assist you if you have any questions at all. Thank you very much.
Thank you so much for sharing with us today, Lawyer Wisdom. We're so grateful for the information that you have given to us. So at this point, I'm going to hand over to my co-moderator, Salam Akaba, if you'd like to take over.
Okay. So I think switching from King Charles land to Uncle Sam, and I would say Uncle Joe Biden, I have the distinguished honor of moderating and introducing Mrs. Laura Adjangba, Esquire. She is a past student of Achimota School, has been a lawyer for 25 years, and has represented clients from over 45 countries. Laura obtained her degree back in 1996 from Temple University, Beasley School of Law in Philadelphia. And after law school, she served as a judicial clerk for the late Honorable June Strelicki, I hope I got that right, a Superior Court judge in Essex County Superior Court Civil Division. Before opening her practice, Laura worked as a supervising attorney for Immigration Representation Project at Legal Services of New Jersey. She's represented detained migrants seeking asylum at the county jails and detention centers, other immigrants throughout New Jersey. Laura's practice focuses on family immigration, VA, WA, waivers, naturalization, removal defense, and BIA appeals. She's very passionate about her work as an immigration attorney. Laura is also the founder of and president of Women Leaders in Action, WLA, a nonprofit organization whose goals are to educate and empower women in self-development through conferences and seminars, and to raise funds and awards scholarships to high school students going to college. Laura is an avid reader, enjoys traveling around the world, and I dare say she's trilingual. So she speaks French, Italian, and is conversant in Spanish. I'm sure there are a couple of other Ghanaian languages that she speaks, so that would add to the tally. She's married and has 2 adult children. So Laura, welcome to the HOPSA USA speaking engagement to talk about US immigration system. So I'll hand it off to you. You're welcome.
Thank you so much. I hope you all can hear me. Thank you, HOPSA USA Canada. Thank you, HOPSA UK. Thank you, Mr. Akaba, for that brilliant introduction. I also like to thank Doreen for putting this together as president. And knowledge, as the old adage goes, is power. So I have been empowered and I've listened to things I did not know from attorney Akaho. Thank you also for that brilliant presentation. So without further ado, I've already been introduced. So I will dig into immigration law as much as I can in 20 minutes. Keeping in mind it's a vast area of practice. So even within immigration, we specialize in certain areas. So I'll go briefly through and try not to be too academic with this. My heart is into naturalization because it's one of the areas to prevent deportation. As a deportation or removal expert, I will touch on the fact that next year is going to be an election year. So if you have not naturalized, it behooves you to do so. The US is one of the few countries that actually accepts dual citizenship. Some countries don't. So you have to check with your country. I heard someone with a question previously regarding that. So if you are able to, depending on your country of origin, please go ahead and do the dual citizenship, because the US does not frown on it. And so you can do both. Then in general, immigration law is based on the principles of reunification of families. And they always want to bring in people, refugees, and promote diversities within the US. Okay. Once you obtain an immigrant visa and you come to the US, you can apply to become a lawful permanent resident. There are several ways of doing that. Now, it's called adjustment of status. Typically, clients come into the US with a tourist visa. That's the usual scenario. And keep in mind, there's a presumption of intent when you apply for these visas. At the embassy or consulate, you tell them, I'm coming to visit. Now, when you come here and you want to adjust your status in the US, you need to keep in mind, they look at, did you change your intent? And that may not be an issue when you marry your loved one and you start doing your paperwork. It becomes an issue at the interview. Why did you tell us you were coming to visit? And then the minute you got here, you got married. So typically, the laws require that after 60 days, it's okay. So don't jump off the plane, get married, and not expect it to be an issue at the interview. Depending on the officer you get, that could be an issue. So keep that in mind. Now, adjustment of status is rather broad, and there are other ways of adjusting your status as well. If you come in, and Mr. Akaba mentioned VAWA, Violence Against Women's Act. Now, Violence Against Women's Act also protects men. So if you're in a valid marriage, good faith marriage, and your spouse for any reason is abusive, you can adjust status or apply for what is known as a self-petition. In that self-petition, you need to explain two things: that it's a good faith marriage and there is abuse. What is a good faith marriage? All the dots have to check off. What were the intent of both parties when they got married? In a case that I had that was being denied, I quickly contested it by showing the intent of the parties. And case law, immigration case law, says that even if the benefits you are intending to receive, it's a green card, it is okay. But that cannot be the only intent of the marriage. Very technical, but can be used. So keep that in mind. Joint documents are proof of a good faith marriage. Did you file your taxes together? Did you take trips together? Did you do other things together? You know, attending events, and so many other things. Your taxes, did you file taxes together? Typically, accountants will tell you file as head of household. For immigration, that's a red flag. It has to be married filing jointly or married filing separately. Keyword, married. So keep that in mind. So VAWA is another way you can show a good faith marriage. Then you go on to show abuse. What is abuse? It's a very general term. If I don't like the way Mr. Akaho is looking, I can tell Mr. Akaho, you're looking rather drab today. Oh my God. Your nose is like that of a pig. That is abuse. So again, you need to go to the experts, because as Mr. Akaho said, when you look at the law itself and you just examine it, you'll be like, oh, maybe I don't qualify. And my first case for a male, even when I went to deportation, immigration court, the judge was like, and she claims she's filing VAWA for, so-called VAWA for a male. And I was like, Your Honor, equal protection under the law. He is also entitled as a man to file for VAWA. So make sure you, immigration is a vast area. Some lawyers specialize in certain areas, some others don't. Make sure you have the right person fighting for you. And then we move on to how to become, and that's another way to become, to adjust your status. It's very critical, but a good way to do that as well. We come to how do you apply for citizenship? A lot of clients do not realize this, that typically when you come and you hang out with your own, they tell you, oh, after 5 years, you're eligible. After 5 years, you're eligible. Well, after 5 years, if you are not basing it on marriage to a US citizen, if you're basing it on marriage to a US citizen, you can actually naturalize after 3 years. Now, the other technicality is this. When they say 3 years, you can actually put in the application 90 days before the 3rd anniversary. Now, if you look at the laws, you may not know. Go to an expert. If it looks like a duck and quacks like a duck, it is a duck. Don't call it an eagle. So you need to be informed. So 90 days before your 3rd anniversary, let's say, I'll use Mr. Akaho as an example. No disrespect to Mr. Akaho, I'm just using him as an example today. Let's say I'm married to Mr. Akaho today. Okay, after 3 years, he's a US citizen. We get married. We get married 3 years into the marriage. So long as we file taxes together and shown documents to that effect, I can petition to become a U.S. citizen on the 3rd anniversary of being a U.S. Permanent resident. 90 days before, you calculate, let's say we got married 3 years ago this October. You go back 2000, this is 2003, you subtract 90 days from your 3rd anniversary, you can put in your application. If that is not the case, then you have to wait for 5 years. And so that is also another way to do it. Same thing, you can put in the petition or application 90 days before the 5th anniversary. Citizenship through U.S. parents. A lot of my clients, I always try to advise, the minute you're eligible, please naturalize. Why? If you have a U.S. citizen, once a parent becomes a U.S. citizen, you have children who are under the age of 18 and are permanent residents, by operation of law, automatically, they are U.S. citizens. So parents, you're not doing yourself any favors. Naturalize quickly so your kids, by operation of law, in other words, once, let's say I have we all came into this country through the green card lottery, whatever, parents, either parent, be it the father or the mother, becomes a U.S. citizen, the children, so long as they're under 18 permanent residents, they're automatically U.S. citizens. This comes to play a lot of times in deportation settings. Sometimes when I go to consult clients at the detention facility, because these kids do not realize that the difference between that and their friends who are U.S. citizens is that they can be deported. So they get into trouble. You meet them at the detention center, they're about to be deported. The first question I ask, and this has prevented a lot of deportations, is are your parents U.S. citizen, either parent? And they say yes. When did your father become a U.S. citizen? The minute you're able to confirm it was before, I have to talk to the deportation officer, stop that deportation. Because they don't ask. Because if the crime is a deportable offense, they're going to ship you out. So that's important. You can also naturalize through military service. Moving on. One of the interesting things about the term, I go into deportation, undocumented. A lot of people come into the U.S. through the back door. Those are undocumented because there's no proof of entry. Once you come in, you end up falling out of status. That is different. You're not undocumented, you're here. So statistics show that there are approximately 11 million people in the U.S. who do not have immigration status. And some of these people have, it says 1.19 million. 1.19 million of them have final removal orders. That is deportation. That is where I come in. That is my area of specialty. Removal is a very tricky area, and I do not advise anybody to do it themselves. But once you end up in deportation, the judge will give you time to present your case. You could file for asylum. You could file for what is known as cancellation of removal. Cancellation of removal, you have to show you've been in the country for at least 10 years. You have U.S. citizen relatives, immediate relatives, who will face hardship if you are deported. And you have to make your case. One of my cases, I had an Indian client whose son went to India with him and then had difficulty breathing, asthma, And so as we were doing the case, it came up that when he came back and the 10 years, he was eligible for cancellation for the 10 years, we couldn't find hardship for this kid. And then God being so kind, 3 months before the case was scheduled to be heard, which is known as an individual hearing. The first hearing is a master calendar hearing, then you have the individual hearing. My client's son was playing football or something and had an asthma attack. Bingo, hardship. So I convinced the judge that this is a U.S. citizen who, if he ends up in India, given the humidity and so on, will be getting asthma attacks all the time. That case was approved. So it behooves you when you are in removal proceedings to get an expert, because sometimes attorneys who do immigration do not do removal proceedings because it's quite, engaging. So it takes a lot from the practice. So make sure. And there are other situations in deportation that you could even seek relief. Asylum is one of them. You can also do that. And for Ghana right now, believe it or not, most of the asylum cases that are coming to play are the fact that members are claiming, because they look at the country conditions. And let me tell you, the immigration judges know about Ghana more than you and me put together. They look to see what is the issue. If you're seeking asylum, you have to seek asylum based on race, nationality, political persecution, and also what is known as a social group. okay, if there's discrimination on that basis, and religious persecution as well. Most Ghanaians now are seeking asylum based on the fact that they'll be persecuted because they're gay, homosexuals, what have you, LGBTQ. When you check the laws of Ghana, well, it's an abomination. So they will look at the country reports for that country and determine. Another basis is FGM. Some of our women in different countries, female genital mutilation, that's a basis for asylum. So you need to make sure there is an application that you file that keeps you in this country. My goal as your immigration attorney is to keep you in this country. So when you are close to the plane, I come to play and I can look and see where and how do I keep you here. I touched on non-citizens with lawful status. And keep in mind, most people don't realize it. I meet clients who've been here for so many years. They've refused to naturalize. I don't get it. Keep in mind, there are crimes called crimes of moral turpitude. And if you are arrested and charged and convicted of those crimes, you are removable, meaning they will deport you. You could have been here for 20 years. That's when all those waivers come to play, cancellation of removal and so on. So just the fact that you've been here as a permanent resident for X number of years does not mean you are okay. You need to naturalize. It's imperative that you do. And even there are so many crimes that are on that list that if you don't take care, you may not even realize it. So keep that in mind. I touched on cancellation of removal. I also touched on asylum. Convention Against Torture is a friend of asylum. That just means that they can, or withholding of removal also. They will not, when you are granted asylum, you are able to travel and become a citizen and so on. Withholding of removal is known as the poor cousin of asylum. If the judge does not feel like you have made your case for asylum, you may be granted withholding of removal. For example, US law shows that you need to apply for asylum within a year of your arrival into the country. So if you face persecution and you apply after the 1 year and you cannot show a good reason, the judge may accord you with what is known as withholding of removal. It simply means you cannot leave the country. We will not deport you for now. So you can get a work permit and be renewing it and be renewing it and be renewing. However, if you have withholding of removal and you end up finding a loved one and they marry you, of course, you can adjust, but then you have to go back to court, terminate. First, you would file for the I-130, which is the petition for an alien relative. Once that is approved, you go to the court and you request administrative closure. And typically, they'll give you that. And then once the case is done, you can do termination of proceedings. Moving on, know your rights. Mr. Akaho touched on this, and I'll also touch on that. As a non-US citizen or non-resident, when you are stopped, it is very confusing for most undocumented people because we're used to giving everything. When they ask you a question, oh, by nature, our culture demands a whole list of answers. For example, if you do a basic greeting in Ghana, how are you? I'm fine. And then the next question, and your husband, and your family, and your mother. Well. That is cultural. When you go to Rome, you do what the Romans do. When you're stopped, they cannot ask you. They can ask you whatever they want to do, but you don't have to answer. But you do it in a respectful manner. I always tell my clients, it's all in the presentation. I myself have had eyes show up at my office to knock and ask questions. And they said, can we come in? I said, no. If you want me to talk to you, we'll talk to you outside my office. And they realized, of course, I know my rights. You can't just walk in without any paper just to have a conversation with me. No. And they wanted the location of one of my clients. I was like, your guess is as good as mine. I don't live with them. Because there's protocol for that. If you want that, serve, a search warrant. There are things for that. But when you're stopped and you're confused, no matter what, the best thing to do is to keep quiet. Listen to the questions, answer. If it's basic information, your name and so on, that's it. Everything else, no, you do not have to. Keep that in mind. Knowledge is power when it comes to that. When it comes to know your rights also, you need to realize you cannot lie. One of my clients was picked up. It was a sad situation. His friend came to visit him from Boston. It was of interest to the officers at JFK. He gave his information, my client's information. So my client lives at the time lived in Jackson, New Jersey. So I think something about his friend didn't sit well when he came from India. So they came to his house. At that point, it's 5:30 in the morning. they are like, we're looking for Laura. And he's like, well, Laura already left. She's in Boston. Well, where are your papers? At that point, you cannot say, I'm not going to give you my papers. In your house, it's 5:30 a.m. Of course, he didn't have his papers. So they took him in and he was bailed out later on and put in proceedings, meaning immigration court. And that is where I came to play, and I was able to successfully get him out. But if they show up at your door, they have to have a warrant. You do not need to open the door. They have to show you that went through the door or through the glass or through the window. They can't just walk in. But we've had situations of ICE sneaking in through the back door. Are they supposed to do that? No. But they always prey on immigrants because, or undocumented, because they know most of them do not know their rights. So knowledge is power. And then online, if you go, there's this card called Know Your Rights. And it's on, Google. You can pick it up. I mean, you can Google it and have it with you all the time if you're undocumented, because it tells you what not to do. You remain silent. And then if you are detained, of course, they will give you a list of pro bono attorneys. But keep in mind, not all of them will take your case. Sometimes you have to retain family members to take on that case and represent you accordingly. So in a nutshell, that is pretty much U.S. immigration law without going into the depths. I think it would behoove me now to touch on some other issues that are not on my PowerPoint presentation that I think are very, very important for you. Social media is your friend and your enemy. Please do me a favor. Not everything has to be on social media. Please. A lot of times, the first thing I ask my clients when I start consulting, are you on social? Oh, yes. I'm like, it's the basic stuff. Oh, I've blocked it. You've blocked it from whom? Immigration is a federal agency. Whatever you've blocked can be seen. And that happens all the time. I had a case where on social media, I believe on Facebook, it was an adjustment of status case for a client, and they were separated, what is known as a Stokes interview. If they don't believe you're telling them the truth or they have an issue with your case, they tell the husband to step out. Of course, the attorney sits in there to take notes. I always do. And the question they asked was, when was the last time your husband traveled? She said, the last time we traveled was when we went to Atlantic City. So how come he was in Las Vegas? She did not know. But one thing I always tell my clients to think on your feet. So they brought the guy in, wife steps out, I'm sitting there. So what happened? You and your friends were in Las Vegas on such and such a day for, how did they pick all that up social media? So then my client says, oh, we had a fight. My wife and I had a fight on Friday. So I told them I was going to hang out with the boys. And when I got to to my friends, they were like, we're going. So I went with them. So I did not see it fit to tell her, so she would not know. We came back, case was closed, off we went. Keep that in mind. But what people fail to realize, too much information. The food you're eating, the drink you're having. Why? Just the basic stuff. Another thing people fail to realize, they put on social media before the immigration officer, and what they will do, they're very sneaky. They'll get up, go to the other room, and come back with the information. What did you do last Sunday? From beginning to end, from morning, whatever. Okay, we went through the questions, everything was looking good, and then the officer came back and said, so why were you at this church event in Maryland when you just told us that you were in New Jersey? Social media again. So be very selective. It's a good way to connect and network, but be very selective about what you post on social media. It can be used against you in a very sly manner. I pretty much touched on most of the things. The other thing I want to say, a lot of times, immigration, the best way to find out information, of course, is uscis.gov. Whatever you hear, just check it out first. For example, what is new now? They're issuing 5-year work permits. It gets on my last nerves. Instead of giving us 5-year work permits, please give us the green card. But the backlog is so severe and annoying that they've realized by the time you get the work permit, it's time to renew it. So the Biden administration went ahead and started giving 2-year. Now it's 5-year. And also, while your case is pending, you need to go home. What I do as a courtesy for all my clients is I petition for advance parole. Why? They tell me, oh, I don't want to go, I'm scared. And I'm like, if they don't issue it for you, you don't have to go. And the reason being that while the case is pending, because it takes so long, God forbid, mom is sick, you have to go, you can quickly make a trip. But please don't make that trip like a 6-month trip, even though it says 1 year. Go quickly, come back. That's the purpose. Advance parole, permission to travel while the case is pending.
Thank you, Laura. Insightful. Can you guys hear me?
Yes.
Okay, good.
And let me please interject for information about me. If you guys, before we go to the questions, because I may get lost in the shuffle, I'm located in New Jersey, Maplewood. But since the COVID, if you don't innovate, you evaporate. So most of my consultations are by Zoom. So you can go onto my website, www.lauraesquire.com, and book an appointment through Zoom. If it's a paid consultation, it will give you access to a link. And once we get that information, we will send you a link for you to book your appointment. You have access to my calendar to book your appointment, make your payment, and then you get a Zoom link from us. And for this reason, I have clients all over the US and some even in Abu Dhabi, all over, because Zoom is the way that business is conducted a lot these days. And at some point, the immigration courts were actually using Zoom also to deport people. So I said, why not? So you can reach me no matter where you are in all the 50 states. And immigration law is federal. So it's the same law. I've gone to Texas to represent clients, Boston, anywhere. It's the same law. The only thing is you have to study and know what the judge wants in each particular situation. So you can reach me very easily on my website, www.lauraesquire.com. It has been a pleasure, and I thank you so much. So I'll take your questions now.
Okay. So we're opening the line for questions if you want to type them into the chat box as well. But just to kick off, Laura, I know you spoke about the DV program. Mm-hmm. How does that impact non-immigrants in trying to adjust their status? If, for instance, somebody has a non-immigrant visa and then gets the DV, wins the DV, what's the process? Is it that straightforward, or have you encountered anybody who has challenges with the diversity program?
Yes, the DV is very tricky in the sense that it's to benefit people from outside coming in, not so much people here. And keep in mind, the way immigration law works is that you have to be in status to change status, except through adjustment through, let's say, marriage or VAWA or anything like that. So if at the point in time you win that lottery and it gets processed, and keep in mind, 100,000 people win the lottery, but 55 or 50,000 visas are available by the time the cutoff happens. So if you are here and you are not in status, you cannot adjust based on the DV. Okay. The only time that if you're out of status, it really doesn't matter. Like I said before, is let's say you came with a visa, you've been here for 10, 20 years, and you find someone and you end up getting married. Even though it's been a while, the fact that you entered legally makes you eligible for adjustment.
Okay. All right. Any more questions? I have another one just to keep it rolling. For students who come in, do the academia, and want to pursue opportunities here, what's the process that they can use? Is it sponsorship through the company? Do they have to get married? What's the compliant path that they can use to adjust their status?
The student visa, clients with student visas, usually it's a very tricky situation. What I try to advise them always, again, is stay in status as much as you can. So after you finish your bachelor's degree, usually you're eligible to do OPT, which is just a chance to work in the system. You can apply through an employer and so on. When that happens and you get OPT status, you can see if you can get organization to sponsor you for the H, so you can keep yourself in status. If that is not possible, what I tell people is try to become a career student, because it keeps you in status so you can do something. So if you can proceed with the master's degree, go ahead. If you can proceed with the PhD, go ahead, because you want to keep yourself in status at all points. However, again, if you fall out of status as a student and you marry a U.S. citizen, you will be eligible for that. But for as long as you can, stay in status within academia, or find a company that will sponsor you. Especially, there are some areas that they look for people very quickly, like IT and so on. it's easier to find. Or sometimes at school, you may be even working at a career center at university, and they need someone. And so long as you're in status, they can switch you to that status very quickly as a student.
I think we don't have any questions, so I'll just add on some more. So you have a relative coming in, has been taken into secondary questioning at the airport.
Secondary inspection.
Yeah, and then sent back to Ghana. Or
turn around.
Yes. How do you, is there any way of helping that person get back in? What does the person need to do?
Okay.
To be able to
I always tell people having a visa is permission to enter the US. It is not a guarantee to enter the US. In other words, a lot depends on what happens at the airport. So let's say you get into secondary inspection. That means they flagged you because something did not sit right with the officer at the first instance. So at that point, they do what is known as, the way you're answering the question does not sit well with them, they do what we call turnaround. They turn you right around and send you back to your country. When you get back to Ghana, it depends on what was stamped in your passport. If there's a bar to you coming back to the US, you need to observe it. And sometimes they may give you a 5-year bar, a 10-year bar from entering the US. That could be the case. A client of mine had that situation where she came in and had a US citizen kid here. But I don't know how they picked up that the cost to the US, of course, because she didn't have any documentation, was very high. So the hospital bill must have been astronomical. I'm not sure. So when she went back to Ghana, she tried entering again with her US citizen son with a visa. They turned her around. The bar was for 10 years. Do not come back in. This is discretionary. And an officer at the airport can do that. So, of course, her 10 years coming up soon, so she should be able to come. So it all depends on what was stamped in the passport. And keep in mind, now everything is electronic. Those were the days where people would give their I-94s to people to go back and forth, back and forth. No, it's no longer the case. The minute you enter, it's in the system. So we can pull up your information and determine when you came in.
Thank you. Any takers for any questions? I just wanted to share an experience. So I was coming from Ghana during the COVID times, or no, during the Ebola outbreak, and I got to Newark Liberty, and the immigration officer there asked me, had I been to any country that had an outbreak of Ebola? And my response was yes, and he flashed up, and it was like, which one? I said the US. And he went pale white, because then Ghana has not received any Ebola cases. So I think what you said about the presentation
absolutely
is key, because he was so flustered and wanted to get into an argument with me, but I was like, well, what I know is Ghana has no reported cases. And he was like, am I the official representative of Ghana? I said, no, I'm flying from Ghana, but Ghana doesn't have any cases. So I think presentation is important.
Absolutely.
One last question before we round up over here. Anybody on the line or any questions on the chat?
Yeah, I have one question. This is John. Yeah, I have one question.
Go ahead.
So what happens when let's say someone has been filed for, a mom has been filed for to come to the US from Ghana.
Okay.
And that mother has a child who's not yet 18 years. And during the file process, they did add a child to it.
Mm-hmm.
What happens to that child?
Okay. I'm just going to summarize what you just said and just correct me if I'm wrong. So someone petitions for someone coming from Ghana, correct?
Yeah, their mom. Let's say their mom.
Okay, their mother. Okay, so you petitioned for your mom, let's say. Let's just put it that way. And your mother did not put all her children on the application, is that correct?
Yes.
Is that the question? Okay. So you can always add the child that was left out, but keep in mind, it would be prudent, and that's what I would recommend, to also do DNA. Because if the child is yours, you could have erroneously left the child out of the application. That would be my argument. But DNA never lies. So once that
Okay.
DNA is a copy of the DNA, one will be done over here in the US, and then of course one in Ghana. Well, if both of them are there, the DNA is done, then you have proof. And of course you can explain, even though they might look at you, they may frown at it, it's your child. And that will just ameliorate everything. And the other thing I forgot to mention is adoptions. A lot of times we try to help our family members by putting on our nieces and nephews on applications. Some countries are more prone to fraud than others. Ghana, unfortunately, is one of them, Sierra Leone, Nigeria. So when that happens, I always advise people, listen, adopt this child and then show that you had dominion and control over the child for 2 years. US law requires that. So if, let's say, I adopt your child, for example, you're my brother, I adopted your son, the son has to be under 16 years to be adopted, to qualify as your child for immigration purposes. Once that's done, it has to be done in the home country. Then you have to show that for the 2 years after the adoption, you were in control of what is known as dominion and control over all his life. School records will reflect you, health records, everything. You hired someone to take care of the person, a nanny, your relatives, or whatsoever. And you've been going to Ghana to visit, because keep in mind, this is your child. So if you show all those things, then once that is shown, you can file for what is known as petition application for alien relative, and then you can go through the process. I had a case in mind, and I'll say this very quickly, and I know my time is up. I had a case where a Kenyan woman walked into my office. She was distraught. Her brother had lived with her for all this time and didn't have any papers. And so he was about to go to college. I mean, not about to go, he was getting to that point. So she came to consult with me. What did I do as her attorney? I advised her to adopt her brother in the US because he was 15 years at the time, and then petition for him to become a US citizen. The adoption, at the time I did adoptions, now I don't. My immigration practice is very demanding. So unfortunately, the adoption hearing was scheduled for the day after his 16th birthday. Now, given that I do immigration law, I quickly went to the court clerk and said, please, whatever you do, give us even the day before the birthday, because it has to happen on or before his 16th birthday. That was done. She adopted him and then petitioned for him to become a permanent resident. So knowledge is power. On that note, I think I will hand over back to you, Mr. Kaba.
Okay, thank you very much, Laura. And I think the keys of the piano from Achimota have been singing today. So
from Gambaga to Accra.
From Gambaga to Accra.
Thank
you.
So
thank you very much. I think for the program, we're going to hand it over to Sister Edna Falconer Thompson to give us the closing prayer and the session wrap up. Sister Edna, please, are you there?
Yes, I'm here. Can you hear me?
Yes, please.
Yes,
thank you. What an awesome almost 2 hours that we've had. Very impressive. I was wondering what I was going to be doing up until the end when I had to wrap up and close up. I did not blink. From our presenters, our moderators, it's been awesome. And as the attorneys have already said, knowledge is power. And boy, have you instilled knowledge in us this afternoon. You know, sometimes we think we know, but there is so much I have learned today from the UK immigration lawyer and from our own here. And we are really privileged to have this information session. I thank all our presenters, all our moderators. Usually I'm not short for words. I'm like blown away. And I'm sure the way I'm feeling is how everybody else feels. And I wish we could have actually had more people because they don't know what they've missed. We thank you so, so much for what you've given us today. It's been a pleasure. It's been a privilege. And you mentioned, Mr. Akaho mentioned so much, and Mrs. Adjangba also has said so much. But a few things come to mind, and especially when Mrs. Adjangba said, our social media. we put so much on social media that at the time, you know, we are having fun, we're posting this, we're posting that. It's all well and dandy, but you don't have to share your life on social media, because you think you've blocked some people, you'll be amazed what you haven't blocked. And like she said, when it comes to immigration, when it comes to the legal services, they can unblock whatever needs to be unblocked. So be careful. Let's learn, all of us, let's learn from whatever has been given us today, which is plenty. Let's learn and make ourselves better. We thank you so, so much. I can't thank you enough. I mean, it's a Saturday, everybody has something else to do. And for these two attorneys to have time to come here and give us so much information, I can't thank you enough. And we had our opening prayer from Sister Rebecca, which was so beautiful. Our moderators, and I'm pretty sure nobody rehearsed this, as none of us did. It's been amazing. And I sure hope it doesn't end here. Let's spread what we've learned. Let's let our brothers and sisters know what they are missing. And I'm glad you both have given us your contact information, so that if anybody missed this session today and really needs to talk to either of you or contact either of you, we know where to go. So I thank you all very much. And I thank all the attendees, because if we had our presenters and we had no attendees, we would have had no session. So I thank all of you for sparing the time and coming together and letting us get this information. And now we are empowered to go do something. We began with a prayer and we will definitely end with a prayer. So can we all bow our heads and say a little prayer?
Amen.
Amen.
Thank you, everyone.